Venezuela's deposed President Nicolás Maduro is currently at a New York court charged with various drugs and weapons offenses. Dramatic images earlier showed Mr. Maduro and his wife, Celia Flores, being transferred to the courthouse in handcuffs, surrounded by armed officers. A long line has formed outside. Everyone wants a seat in the room where Maduro and Flores were expected to enter their pleas. The pair were taken from their Caracas compound on Saturday and flown to the U.S. as part of a special forces operation. At an emergency meeting of the UN Security Council, Secretary General Antonio Guterres says he's concerned rules of international law have not been respected. Meanwhile, Venezuela's new leader, Desi Rodriguez, is due to be sworn in before the country's National Assembly. Let's bring in a former United Nations envoy and professor of human rights at Bournemouth University in the UK, Professor Uchenna Emeloye, for more on this development. Prof, thanks for joining us. Given what we know, the U.S. carried out a direct military intervention in Venezuela, seized President Maduro in Venezuelan soil without prior UN Security Council authorization, and then brought him to the U.S. to face federal charges. How does this square with international law, especially the UN Charter's prohibition on the use of force against sovereign states?
I would want to anchor my response very strongly on the statement of the United Nations Secretary General, where he has expressed some reservations about this development. Even though he sounded as diplomatic as a UN Secretary General would sound, but I would want to sound tougher on grounds of law, that this development in Venezuela and the United States is concerning. It's a development that is worrying, anchored on international law. We all agree that the core principle of international law is sovereignty. And the essence of sovereignty is to protect and guarantee equality of states, irrespective of power, irrespective of authority, irrespective of number, irrespective of ideological leaning. This is a principle. Every sovereign state is granted the equality of sovereignty under the Charter of the United Nations. So in principle, there are exceptions to the issues of sovereignty, and I'm not sure that those exceptions have been met in this particular instance. The first exception is in self-defense. I'm not sure, I don't have the facts that the US government would have, whether the arrest can be justified on grounds of self-defense. The second exception is a United Security Council resolution, where it now becomes a collective action of the international community and not a unilateral action of a member state of the UN. So I would say from the point of law that this is very concerning that this development has happened. Today it's an attack on Venezuela. Tomorrow it will be an attack on one of the countries in the global south. What is wrong is in allowing this precedent to happen. And interestingly, the president is appearing before the court. But the question is, can a sovereign authority, can a sovereign judicial system impose a trial of another sovereign country without the concurrence of the UN Security Council? The answer is no.
Interestingly,
the only court that can do that is the international court.
It will seem that there's divided opinion with the way world leaders are reading the room. From a human rights and sovereignty perspective, how should the international community view the legitimacy of Maduro's detention and his arraignment in the U.S. federal court, especially when Maduro himself, just minutes earlier, pleaded not guilty and continues to assert he remains Venezuela's legitimate president?
Obviously, he is the legitimate president of a sovereign country. In any case, he has a personal immunity as a president. So how do you vacate a personal immunity by a single country without going through the judicial process by an international court? The worrying aspect of this is it's a threat to the global south. It is a threat to small countries that you must be aligned to the superpowers to exist. And the essence of the UN Charter is to protect states on grounds of equality. So it's irrespective of how countries interpret this. There are bound to be alignment. There are bound to be ideological inclinations on this. But I speak on grounds of law. There are a lot of unanswered questions based on international law in terms of the arrest and the prosecution and the trial that is happening in the United States after an arrest in a sovereign country in Venezuela. It defiles the logic of law that every member state should be given the equality of arms to exist as a sovereign country. If there are exceptions and needs for these exceptions, it must fall under the laws as well, which I said earlier, on grounds of self-defense and collective actions of the Security Council. And to the best of my knowledge, the UN Security Council is yet to debate this and yet to authorize an invasion of Venezuela, either in any form whatsoever.
You know, you were talking about the comments by the UN Security Council, the UN Secretary General, and that has also come under strict scrutiny, with many critics saying perhaps the United Nations seem to be a dog that can bark but cannot bite. Looking at the developments now, Delcy Rodriguez is due to be installed as interim president by the National Assembly. There are conflicting statements over U.S. control, its cooperation, and even Venezuela's own constitutional process. What do you think the human rights and governance risks are now for Venezuela and the wider region?
The risk is this is a wrong and dangerous precedent. This is not an issue for Latin America. This is an issue for the world, and particularly for the global south, and by extension, because I'm African, for African countries. It's a threat. It's a danger. It's dangerous. And I would forgive presidents if they sound diplomatic without outrightly condemning it. That is the way diplomacy works. I mean, member states and countries will disassociate themselves from this action, but stop at condemning it. But I mean, we have been trained as human rights experts to speak truth to authority. And part of this speak to authority is the fact that this action runs the risk of violating the international rules, international norms, and international standards. The UN Secretary General has said it, and he said it on behalf of the world and member states of the UN, I think 143 members of the UN at this stage. Yes, critics might disagree with it. Critics might say that the UN is a lame dog. UN has not taken any action. But the essence of multilateralism is to prevent countries to unilaterally act, even when they act in good interest, even then when they act for a good purpose. The objective rule is collective action, and that is the principle that the UN agreed in 1945 when this world order was established. It does not give leeway for unilateral actions by countries, big or small. In this case, it's a bigger country against a smaller country, and by extension, if this precedent is established, I fear what will happen in the global south going forward, particularly when some countries disagree with the internal runnings of some countries in the global south.
You know that parts of U.S. action include threats of further strikes if the Venezuelan government doesn't behave. We're also hearing about temporarily running the country's oil sector. And you are particular about the threat to the global south. What can they do now, especially with the kind of measured and diplomatic response we're getting from the UN?
What is happening now is gunboat diplomacy, where states are forced and coerced on the authority of the powers of the gun. The powers of the gun is not the legality of the issue. The UN is built on the legality and the sovereignty of states. And this precedent, it's such that some member states, and I would concede to them without being critical, would not come out to condemn these actions. There have been so many issues where this condemnation did not come out very strong. But as a former UN envoy, I feel pleased that the UN Secretary General even took a position, even though not very strong. But that statement, in effect, presupposes the fact that he is not sure that the international law was respected in the course of this arrest. And maybe because I work in a personal capacity at this stage, And for the fear of personal repercussions, the truth should be told, and this truth should be told to the big authorities and big powers, and that sovereign nations are entitled to several rights and privileges. One of them is the sovereignty of the territory. The territory. Secondly, the fact that law enforcement cannot be transplanted from one country to the other, except through the authority of the International Court. The first court is the International Criminal Court. If there's an order of International Criminal Court, remember, the enforcement requires cooperation. It requires a collective action. But in this case, I'm yet to read, I'm yet to be educated whether this action was taken collectively by member states of the UN, collectively by a region, collectively by an entity. I'm not sure. It is just by one state, unless I'm proven wrong. But if it is just by one state unilaterally, it does not sit well with the international law requiring territorial integrity and sovereignty of member states of the United Nations.
And I understand all the interpretation. The question remains, the U.S. has done what it intends to do. What will the world do about it? But it's a good place to leave it. Former UN envoy, Professor of Human Rights at Bournemouth University, Professor Uchenna Meloye, thank you so much for talking to us.
Thank you so much.